The federal indictment has been filed. Donald Trump now faces criminal charges from special counsel Jack Smith that legal experts are calling the most serious threat to any former president in American history. We're talking about 37 counts spanning classified document violations, obstruction of justice, and conspiracy to defraud the United States government. This isn't another investigation or inquiry that might fade away. Federal prosecutors have presented evidence to a grand jury that returned true bills on each count. When career Justice Department officials who've spent decades avoiding political cases unanimously recommend charges this severe, you know something catastrophic has shattered every norm of presidential accountability. Hit that subscribe button right now because you won't want to miss any of the videos I release. So what set off this unprecedented move? A 49-page indictment unsealed on January 28, 2025, alleges Trump personally ordered the concealment of classified materials after multiple federal subpoenas demanded their return. Sources reviewing the charging documents say there are recorded conversations, testimony from Trump's own attorneys, and surveillance footage from Mar-a-Lago showing boxes being moved to avoid FBI inspection. This isn't just another political controversy fueled by partisan interpretation. Multiple members of Trump's inner circle cooperated with prosecutors under immunity agreements. And believe me, when your own lawyers testify against you in a federal criminal proceeding, something enormous has just detonated in ways that can't be walked back or spun away. Here's the full picture of what's been unfolding. Tensions between Trump's legal team and the Justice Department have been escalating since the August 2022 Mar-a-Lago search recovered over 300 classified documents. But everything reached a breaking point on January 15, 2025, when prosecutors obtained recordings of Trump instructing aides to hide materials from his own attorneys. The recordings, made at Bedminster in June 2023, allegedly capture Trump saying, "Move those boxes to the storage space they haven't searched yet. They can't take what they can't find." According to the indictment, Trump personally directed obstruction while classified documents on human intelligence sources, nuclear capabilities, and military plans remained in unsecured locations. Prosecutors claim he ordered relocation of materials on 4 separate occasions to avoid subpoena compliance. Smash that like button if this is making sense so far. Here's where it really gets serious. When grand jury members heard testimony from former White House counsel Pat Cipollone, they were presented with notes documenting explicit warnings to Trump. Legal analysts say Cipollone's May 2021 notes show he told Trump that holding specific intelligence materials violated the Espionage Act. And let's be honest, presidential indictments don't happen over technical violations. They happen when prosecutors have evidence of intentional criminal conduct endangering national security. On January 22nd, Jack Smith's team presented what witnesses called the most damning evidence in a marathon 7-hour session. The presentation included 47 recorded conversations with Trump's voice, giving direct instructions about concealing materials. Sources told The Washington Post one July 2023 recording allegedly captures Trump showing classified documents about Iran's nuclear program to visitors at Bedminster while stating, "This is secret information. I probably shouldn't be showing you this." That recording alone constitutes multiple felony violations under federal law. Trump's attorney Evan Corcoran testified under crime fraud exception that Trump prevented him from searching areas where documents were later found. Corcoran's testimony included a meeting where Trump said, "You don't need to look everywhere." The grand jury deliberated 3 hours before indicting on all 37 counts. Drop a comment right now if you saw this coming. I read every single one. Now things get explosive. Judge Tanya Chutkan ordered Trump surrender his passport immediately and prohibited travel outside the continental U.S. Her tone was notably stern, stating the charges presented grave concerns about obstruction and potential witness tampering. That's when it became clear this isn't another dragging investigation. Jack Smith appeared at a DOJ press conference on January 29th. His delivery was deliberate and prosecutorial. He read from the indictment, "The defendant did willfully retain documents containing classified information relating to national defense, knowing that unauthorized disclosure could cause exceptionally grave damage to national security." He paused. The evidence shows that when the government sought return of these materials, the defendant engaged in conspiracy to conceal, remove, and destroy evidence, to make false statements, and to obstruct justice. When a special counsel publicly details evidence, including recordings of the defendant admitting to crimes, the partisan witch hunt claims collapse. This isn't built on circumstantial evidence. The evidence includes Trump's recorded admissions and testimony from his own attorneys. Think back to Nixon and Watergate. Republican senators told Nixon he'd lost their support. The pressure grew so intense, senior GOP leaders told him he couldn't survive impeachment. Nixon resigned within 48 hours. But Nixon was never criminally indicted due to Ford's pardon. Then Hillary Clinton's emails. FBI Director Comey said her private server was careless, but recommended no prosecution because they couldn't establish intent, and she cooperated fully. The difference here is stark. Trump's case involves recorded evidence of him ordering concealment, refusing to cooperate, and allegedly instructing evidence destruction. Subscribe immediately if you haven't yet. Trump's first impeachment saw Republicans maintain support despite Ukraine pressure evidence. Now it's different. Prosecutors have Trump's voice on tape allegedly admitting to crimes. When presidents abuse power threatening national security with documentary evidence, even loyal allies reach breaking points where legal reality overrides partisan loyalty. According to legal experts who reviewed the indictment, Trump's actions violated core Espionage Act provisions protecting sensitive intelligence. The indictment alleges he retained top-secret SCI documents, including intelligence methods, covert source names, and nuclear contingency plans. These materials never legally belonged to Trump personally. Here's the kicker. The indictment includes surveillance footage showing Trump's valet moving boxes hours before Trump's attorney arrived to conduct the certified search. Footage time-stamped June 2, 2023 at 10:17 a.m. allegedly shows 27 banker boxes moved to an area never searched. This wasn't about records disputes. It was deliberate deception to obstruct subpoena compliance. Don't go anywhere. The most explosive part is coming next. If someone who served as commander-in-chief can retain sensitive intelligence, refuse lawful return demands, instruct others to conceal it, and face no consequences, national security law becomes meaningless. Once that precedent is set, no mechanism prevents future presidents from treating classified intelligence as personal property. This puts Republicans in an impossible position. One side demands they dismiss the indictment as persecution and attack Jack Smith. That narrative requires threatening to defund the special counsel and framing this as election interference. On the other side, they must defend someone who allegedly showed classified war plans to journalists while recorded saying he knew it was secret. That becomes impossible when military families ask why security depends on whether commanders like classification systems. There's no credible legal defense. Either recordings are authentic, making Trump's conduct indefensible, or prosecutors fabricated evidence, including testimony from Trump's lawyers who'd face perjury charges if lying. The conspiracy theory required involves Jack Smith, multiple grand juries, Trump's own counsel, and staff all participating in elaborate frame-up producing recordings of Trump's voice. That's not legal defense. That's requiring belief the entire federal justice system engaged in criminal conspiracy. Lawrence Tribe, Harvard law professor, told MSNBC the evidence represents the most clear-cut case of criminal conduct by a former president in American history. The recordings alone would be sufficient to convict. Do me a favor and slam that like button because it genuinely helps this video reach more people. Andrew Weissman, former federal prosecutor on Mueller's team, noted Trump's biggest problem is the obstruction. In similar cases with less sensitive materials, prosecutors obtained convictions with 36 to 48-month sentences when defendants obstructed. With evidence this strong involving materials this sensitive, Weissman suggested sentencing guidelines of 10 to 15 years. Even Jonathan Turley, conservative GW law professor who frequently defended Trump, acknowledged the allegations are extraordinarily serious. He stated that if recordings match indictment descriptions, they constitute exceptionally powerful evidence difficult to overcome. Let's break down what this means. First, Trump faces 37 federal felony counts, many carrying 10 to 20-year maximum sentences. A conviction on multiple counts could result in 8 to 12 years recommended sentence. At 78, Trump faces potentially spending his remaining life incarcerated. Judge Chutkan's passport restrictions indicate she views him as potential flight risk. Second, this changes 2024 completely. Trump faces trial tentatively scheduled September 2024, weeks before the election. He could be at defendants' table watching prosecutors play recordings of his voice during campaign season. Republican voters must decide whether to nominate someone who could be a convicted felon by Election Day. Finally, implications for executive power are profound. For the first time, a former president faces criminal trial for conduct in office. A conviction establishes presidents face same criminal laws as ordinary citizens. An acquittal, despite overwhelming evidence, suggests the presidency places individuals beyond accountability reach. Drop a comment below with your thoughts. Beyond immediate fallout, this is about fundamental constitutional principles. The commander-in-chief role requires access to the nation's most sensitive intelligence. That access is granted through security clearances built on trust. If presidents treat intelligence about nuclear capabilities and military operations as personal possessions shown to visitors, information security collapses. Allies will question sharing intelligence with the U.S. if former presidents treat it casually. If there are no consequences for this alleged conduct, former presidents can essentially declassify anything through actions, keep whatever materials they choose, show them to anyone, and obstruct investigations. That's not sustainable for protecting national security. It's a blueprint for catastrophic intelligence failures when adversaries gain access. This caused chaos within Republican leadership. Emergency conference calls happened all weekend after the indictment. Some argued to distance from Trump immediately and consolidate around another candidate, warning that defending him through criminal trial would be catastrophic. Others insisted the base remains loyal and abandoning Trump now would fracture the party. The party is tearing apart over whether loyalty to Trump outweighs self-preservation and law and order principles Republicans traditionally championed. Trump's supporters are enraged. Social media erupted with calls to defund Justice Department, investigate Jack Smith, and primary any Republicans suggesting Trump face accountability. The base views this as ultimate political persecution. To them, the indictment confirms Trump represents such an existential establishment threat, they resorted to Soviet-style show trial. Trump responded, calling the indictment the most egregious weaponization of justice in history orchestrated by Biden to interfere with elections. He denied wrongdoing, claimed he declassified everything mentally before leaving office, and characterized Jack Smith as a deranged prosecutor being used as political hitman. Trump attacked Pat Cipollone and Evan Corcoran, calling them weak lawyers who caved to pressure. The statement concluded with fundraising and a promise this will backfire spectacularly. Stay with me. What comes next will completely change how you view the political landscape. Here's what makes Trump's response legally catastrophic. Instead of substantive legal defense, the entire response attacks prosecutors, attacks former lawyers, claims mental declassification powers with no legal basis, and appeals to base to view this as persecution. When your response to criminal charges is attacking everyone involved, you don't have viable defense to charges themselves. Trump's statement created multiple legal problems, claiming mental declassification is legally meaningless. Declassification requires following specific procedures. Presidents cannot retroactively declassify through mental processes. Even if somehow declassified, Espionage Act charges don't require current classification. The statute prohibits retention of national defense information when unauthorized disclosure could harm security. Attacking cooperating witnesses publicly could constitute witness intimidation, potentially adding additional charges. This goes beyond one former president. It's about whether someone who served as commander-in-chief can treat the nation's most guarded secrets as personal property, refuse lawful return demands, and orchestrate obstruction without consequence. If Trump can do this and walk away because his base views accountability as persecution, the message to every future president is clear. Classification has no teeth. Obstruction has no consequences. National security laws don't apply to those who held the highest office. If this blows your mind, hit that like button right now. Here's the brutal reality. A bipartisan group of national security officials from Republican and Democratic administrations issued a statement expressing grave concern. The group included former CIA Director Michael Hayden, former DNI James Clapper, former Defense Secretary Chuck Hagel, and former FBI Director William Webster. They emphasized the alleged conduct endangered intelligence sources and methods, compromised ally relationships, and undermined information security protecting the nation. When Trump's own White House lawyers testified they warned him his conduct was illegal, when you have recordings allegedly admitting he possessed and showed people classified information, when you have surveillance footage of boxes being moved to hide them from his attorneys, and when you have documents about nuclear capabilities found in unsecured locations, this isn't a close case. This is the kind of case federal prosecutors almost never lose. Keep close eye on several critical dates. Trump's arraignment is February 3rd, where he'll plead not guilty and file motions to dismiss. Legal analysts say these motions will likely fail, but could delay trial months. Trial is tentatively September 2024, but could move based on discovery volume. Judge Chutkan will implement procedures for handling classified materials, adding complexity and potential delay. Watch for whether other jurisdictions bring charges. Trump could face state charges in Florida for the same conduct. The January 6th investigation is reportedly moving toward charges related to overturning 2020 election results. Trump could face multiple simultaneous criminal trials throughout 2024. Before we go further, smash that subscribe button so you never miss updates. Here's where things stand right now. Donald Trump has been indicted on 37 federal felony counts related to willful retention of national defense information and obstruction of justice. The evidence allegedly includes recordings of his own voice admitting to crimes, testimony from his own White House lawyers warning him his conduct was illegal, and surveillance footage showing efforts to hide materials from investigators. He faces trial beginning September 2024, weeks before voters decide whether to return him to office. Judge Chutkan has restricted his travel and required passport surrender, treating him like any other defendant facing serious federal charges. Military families, intelligence professionals, and national security officials across the political spectrum are watching to see whether someone who held the nation's highest security clearance faces accountability for allegedly treating America's most sensitive secrets as personal property and showing them to unauthorized individuals while recorded saying he knew it was illegal. Meanwhile, Republican Party leadership faces an impossible choice between defending Trump despite overwhelming evidence and fracturing a base that views any criticism of him as betrayal. Some GOP leaders are quietly exploring paths to distance from Trump, while others double down on claims of political persecution despite recordings of Trump's own voice allegedly admitting crimes. This isn't just another news cycle that will fade into background noise of political controversy. This is a constitutional crisis playing out in real time where the fundamental question is whether former presidents are subject to the same laws as ordinary citizens or whether they operate in a consequence-free zone where national security violations carry no penalty. What happens in this trial could determine whether the presidency itself has any meaningful constraints at all, or whether future presidents understand they can abuse classified information with impunity. The precedent set here will govern executive accountability for generations. The evidence prosecutors have compiled is, according to multiple legal experts, the strongest case ever brought against a former president. The charges are the most serious, the potential sentences are the longest, and the political implications are the most profound. Trump has spent years claiming witch hunts and political persecution, but this time prosecutors aren't relying on testimony he disputes or documents subject to interpretation. They have his voice on tape allegedly admitting he retained classified information he knew he shouldn't possess and showed it to people without clearances. That's not political persecution. That's evidence that speaks for itself. The stakes have never been higher for Trump personally, who at 78 faces potentially spending his remaining years in federal prison if convicted. The stakes have never been higher for the Republican Party facing a choice between law and order principles and tribal loyalty to a leader whose own recorded words may convict him. And the stakes have never been higher for American democracy itself as we confront whether accountability applies to those who held the highest office or whether the presidency places individuals permanently beyond the reach of justice. The answer to that question will define the limits of presidential power and the meaning of equal justice under law for decades to come. Pause for a second and hit that like button if you're finding value in this comprehensive coverage of what could be the defining legal and political battle of this generation.